Petition allowed. Order is to post pending either also dismiss interim order if any standpoint. Petition stands allowed. Petition stands allowed.
I have for seeking certain modification. Kindly allowed to get more. Some emergency there is also connected to contempt case, personal action.
I filed in what?
Contempt.
Contempt case. Where is the contempt case fixed?
Allowed that matter is 29 for personal action. They request I will. That's the matter.
The contempt case is already fixed.
Yes, 29.
You are for the petitioner.
I am for the respondent. The action was given for personal offense, but there is a two variation. The notice says that depended by the advocate also, but order says something else. Therefore, certain clarification. I seek accommodation in item 21, my lord. I have some personal difficulty today, my lord, not keeping well. Can it be, my lord, on any other day?
This matter has been adjourned.
I understand. Mr. Sharma was actually unwell for a long period of time.
Issue, but you're not interested because what is the point in filing an arbitration petition for appointment of an arbitrator? It's getting adjourned and adjourned and adjourned. Either you mention or the other side mention.
I understand.
What is the problem?
Sharma was actually not keeping well for a long time. Today I have some personal difficulty.
So we'll have it tomorrow.
Day after, man. Day after, tomorrow, man. Day after would be better.
Day after.
Okay.
Day after.
Deeply obliged. Second of day.
Mention you approach the registry, then get it. So before the registry that these matters are parted, it's to be listed, they'll put it up. Why do you have to mention it? Is it mentioned in the order that this is parted? Then you show the registry, then get it listed. You don't have to mention it.
It's a family pension matter, admission matter. Day after tomorrow.
No. Which year?
2022.
Then
Madam, it is going
where were you for 3 years?
No,
4
madam,
years?
it is already going on. Last list is 69/2025.
So where were you?
My lord, I'm pursuing this one, but I'm the respondent, madam. They are enjoying interim order.
They are enjoying interim order. You file an application seeking vacation. Was it an ex parte interim order?
My lord, actually, it is
was it an ex parte interim order? Interim order enjoyed by the petitioner.
Petitioner.
Was it an ex parte?
Not ex parte. Ex parte, madam. Before that,
ex parte, you file your application for vacation.
Otherwise, my lord, it is going to conflict, madam. Treating is conflicted.
Whatever it may be, it's no way 22 matter will suddenly come up day after tomorrow. Without any explanation, what has happened for the last 4 years?
Actually, it was said for my lord for mediation. Mediation failed.
So let it come in May. Or if you want, you file an application for vacating stay.
First week of May.
18 May.
Right. 27 months. Pertains to non-payment of base rate.
27th is not possible. So this will be in May.
Payment.
20 May. 0. 20.
Fine. Maybe.
at the party. Last fixed on 10th of this month, but that was a holiday. Can it be next
For admission,
admission? Either 29, 30.
right, 29.
It is a lordship. Lordship, concern of the other side, I beg to mention, item number 13. Lordship kindly adjourn the matter for today.
Item 13 of the request made by you are appearing on behalf.
On behalf of the petitioner.
Who made a mention for
T.
listing? Huh?
T. Mohan on behalf.
The matter is listed by order. Somebody mentioned it for listing it today.
Yes, sir.
Who mentioned it?
We are unaware about that, your lordship.
What do you mean? You check the file and make a submission accordingly.
But then, your lordship, the respondents have not.
Have you seen the check host list? Do you have the host list with you? Is it item 13 or 14?
13.
13. 13 is shown
I
as
am
by
the
order.
respondents. I had asked the unit counsel for the request.
Please ask for a VC request in item 13.
For their request for adjournment came, Mr. SK Singh leading this matter for the respondents. He had applied for VC.
No, but you mentioned it.
We have not.
You check it. Some file to some. What is saying that it is listed by order, you should have the courtesy to at least go and see the file and tell us. Who is Mazidur Islam? Mazidur Islam? M. Das and M. Borgohain.
They were in our chamber.
Where are they?
They are not engaged in this matter.
So this somebody mentioned
They have.
Mazidur Islam mentioning, showing your names and the name of Mr. Ganguly also. Respondent. What do you mean no? Have a look. What the hell? Find out who is this lawyer who made a mention in your matter and you are not aware. The matter is listed as by order. Take up and come back. Yes.
Item number 20, my lord. I have obtained consent from the other side, my lord. My senior is
20. 20.
Yes, my lord. My senior is unable today, my lord.
2 to 9. 18 and 20 wrongly listed. So no mention required.
Black.
I did mention for this. On receipt of pensionary benefit. Admission.
Admission matter. Which year? 6th of May.
I have moved an adjournment slip regarding item number 12, man.
Item
12.
12.
But each of these outer station, man. I am for the respondent for the application.
Item 12 would be list.
Respondent.
By the respondent. Matter stands before. Listed after 2 weeks.
Maybe little. I am praying for a petition 8/2026. Lordship, the matter is very urgent in the nature that this petitioner is the co-wife of this respondent number 6, my lordship, and this court, honorable court, has passed an order to fix this matter against service has been served, my lord. Can it be kindly the next week
Don't know what has been ordered by the court.
by this court to serve the notice to the respondent number 6, who is
Have
the
you
first
served?
wife? Yes, my lordship. So speed push,
Through.
speed push, my lord.
So let the file these reports with the registry. They will give an endorsement and thereafter it will be listed.
May I please, I would like to mention for listing of the contempt cases, maybe next week.
Contempt matter. 29.
Madam, I would like to mention for listing the admission column 1 petition, because last listed on 2011.
With petition. 11th May.
Yeah, please, Your Lordship, I beg to mention item number 4 to 10.
4 to 10.
Yes,
Yes.
it's time to file affidavit of petition.
You have taken consent.
Yes, consent taken. And adjournment slip.
4 to 10, the request made by the parties by circulating the district stands referred to the district after 4 weeks.
Much of
Lordship, I beg to mention.
2020?
Last
What?
posted.
Why were you not pursuing the matter? 11th May. Yes, yes.
Yes, please, Your Lord. Lord, item number 15, Lord, with the consent of the opposing party, Lord, we are praying for an adjournment today. Lord, Mr. Senior Counsel, Mr.
Item 15.
15, my Lord. This one, my Lord, 12, 19, or 21. Immediate condition of the 12, 19, or
21.
21.
May please, Your Lordship, with the consent of the other side, I beg to mention item 14. On the private respondent number 4. My Lord, we filed the affidavit in opposition yesterday and the same is not on record.
For others to make a mention, why are you making a mention? You have filed it.
Yes.
Who's for the petitioner? You have taken consent? No.
Yes, my Lord.
You have taken
Yes,
consent.
yes.
Item 14 on the request made by Ms. S. Sharma.
Hazarika.
S. Sharma Hazarika, very correspondent, stands before. Stayed after 3 weeks. No fixed date. It's already fixed today. You are agreeing to an adjournment. Yes.
Okay.
Your Lordship, I like to beg for listing of the that's not come up quite a while. 10-3.
13th of May.
Lordship, I'd like to mention for listing an arbitration petition.
Arbitration.
Yes, Your Honor.
29th. Sorry, 22nd. Day after.
Yeah.
Lordship, I spoken to the council and mentioned the matter, Your Lordship. Mr. Mazin. Lordship, the council is very engaged by him, Your Lord. He had not informed about the matter.
Good.
Lordship, may kindly adjourn the matter for today. We have taken consent and informed.
Item number?
13.
Item 13 on the request made by Mr.
A Goswami.
A. Goswami, petitioner. Then it's referred to be listed after 2 weeks.
Lordship, may this arbitration petition be listed on 24, on 22, my senior will be out of
As
date.
24 is not possible, then it goes to
Monday,
4th of May.
much
4th of May. Given on the request of the council for the petitioner. Matter stands referred to be listed after 4 weeks.
Madam, may please, Your Lordship, I am praying for listing of this matter today before court number 23, my lord.
Why?
Along with item number 46, these are similar matters, my lord. In fact, on the last occasion,
So I can only grant you permission to have matters listed before this court.
they made a mention before court number 23 yesterday.
Ah.
Since Lordship is taking up the bench 3 matters, senior bench, my lord.
Ah.
We are directed to make a mention before Lordship.
So wanted listed.
Yes, madam. And before court number
That
23,
we can't do. We can grant you listing here.
yesterday we made a mention before court number 23. Since Lordship
What
is
is 23? What bench is the court taking?
my lord, criminal matters and along with this part-out matters, my lord. This is a part-out matter, this is service matter, my lord.
23 is taking up service matters.
Criminal
Sorry,
matters and
which bench?
my lord, Justice Rajesh Mohan.
He's taking up what? Bench
Criminal
three?
matters and he has taken up, my lord. But my lord, these matters are fixed for further hearing. Service matters, my lord, I was here.
We can't mention it here. Take it up with the registry.
My lord, and the block.
Listing of a matter, my lord. First week of May, my lord. 2024 matter.
First week of May, not possible. 11th May.
Okay.
Wait, with the consent of the other side, I beg you, but item number 3, it's a 2019 matter, but I have been recently engaged. But preview, can it be on next week?
Item 3.
Yes. for the obliged lordship.
Submits. Why you don't want to press?
You already got the appointment.
Services.
Central arm. Yes, sir.
Under which course?
Product security force.
So, press will be-
Public. Your lordship, Mr. I. Waterford is holding the brief. He has some personal difficulties. Any date, your lordship.
Did you not inform the council for the petitioner? He's on virtual mode.
Your lordship, the council may proceed.
Lords, item number 1, my lords. On the very last occasion, my lordship heard this basically a parted matter, my lords.
When you inform that the council for the respondent is
Just-
making a mention,
Just now, the time.
why did you not make a mention? Why did you not inform the other side? This is a parted matter.
At the time of mentioning.
That's a courtesy you should show. Why have you not mentioned?
Your lordship, yes, not reachable.
Huh?
He has some personal difficulties.
He has some personal difficulties. You should make a you should inform the other side well in advance. He cannot come to the court. He should inform the other side.
Your lordship,
Yes.
he informed at the time of mentioning while other persons will mention.
Where is Mr. B Goswami? He was appearing earlier. Additional AG.
I'm not aware.
You are not aware. It is evident in the records. You are making a mention. At least you must do justice to yourself to look into the brief to find out what is the matter you are making a mention. You project yourself to be an officer of the court. You must behave like one. You can't stand up before the court and say you don't know. Why are you before the court then?
I'm for the lordship, I'm for the respondent number 4 APDCL. And this some is for respondent number 1, 2, 3.
Where is Mr. B Goswami? Send me. Mr.
Prerit
Mr.
Goyal.
Goyal.
Prerit
You're
Goyal,
Mr. Goyal.
my lords.
Yes, yes. We'll just call up the matter a while later.
My lords.
We have sought for the additional AG who was appearing in the matter.
My lords.
We'll call it up in a while.
My lords.
Thank you, Swami.
Admit constable is dismissed for service due to his another absent. In this case, nowadays my limited period. This is his financial year. Only discharge certificate he has not issued.
Discharge certificate.
Discharge certificate as per rule 28.
Which rule?
As per rule Army rules 19 rule 12.
Army rule.
Section 20.
Army rule
12. 23.
He was serving as what?
Constable, Army Constable.
Does it make him a JCO? He's not a JCO. This certificate,
Well, discharge certificate required to be furnished under the Prohibitions called discharge certificate. Discharge certificate may be furnished either by person physically, either on behalf of commanding officer, the person dismissed, remove or discharge or release.
what do you say, Mr. Bora?
Lordships, if his court was submitted with punishment of 30 days jail, those who are given discharge on disciplinary ground, they are not given this discharge.
23 of the kind of act.
The section 23 does not make any distinction.
That's true, Lordship.
Then section 23 says that person should be released. Person should be issued the certificate.
The practice going on of person, those who are terminated on disciplinary ground or face court martial, they are not given this certificate. First thing he has been granted account has been financially he is not entitled to anything. All things are paid. He admitted.
But why this army rule is, how is it applicable to?
It's Army Constable.
It's an army council.
So he has a separate army.
Next,
Army.
He was a sepoy.
Sepoy.
You give him a discharge certificate.
Lordship,
That will close the matter.
that's it.
Right. Urgent for parties. The petition. Serving sepoy of the Army Supply Corps. So petitioner was dismissed from service on 11/9/1999 due to unauthorized leave. Petition was filed by the petitioner, being WPC 312 of 2000, challenging his dismissal. Thereafter, submitted several representations to the high authority seeking release of his statute. Since these benefits were not granted to the petitioner approached his court by filing. So the matter was issued. submitted that, submitted by the council to the commission, that legal dependency petition. The benefits benefits, financial benefits, which service benefits entitled to the petitioner came to the release, and he has received all the financial benefits. So, however, the discharge certificate required to be issued by the army authorities was not released. So, counsel for the petitioner has referred to 12 of the army rules to submit that the discharge certificate is required to be issued by the army authorities. Stop, however, same has not been done in spite of mandate in the rules, mandate in the Army Act. CDC Boral and CDC on the other hand submits that discharge certificate is generally not issued. It's not issued to persons who have been court-martialed. So the petitioner was court-martialed and dismissed from service, and therefore the question of issuing a discharge certificate. Having heard the counsel for the party, it is necessary to. So upon perusal of the Army Act, the rules, see that the rule 20, section 23 provides for certificate on termination of service. Stop section 23 says under how certificate is to be issued under section 20. Described under 12. 12 of the Army rules, 1954. Well, you see that any person who is dismissed, any enrolled person is dismissed, discharged, retired, released from service, shall be furnished by commanding service certificate in the language which is his mother tongue, and also in English language, stating the authority terminating service, cause of his termination, the full period of service. And a rule 12 describes the procedure how a discharge certificate is to be furnished. Reading of section 23. That discharge certificates are not to be issued to person who were dismissed upon being court-martialed. Mr. Bora is not proven, which provides for an exception for discharge certificate issued under the 23. Is there any judgment to that effect that it cannot be produced? Such circumstances, school considered that where the statute mandates issuance of a discharge certificate, So it's following the directive. Who is to issue it? Commanding officer.
Commanding officer.
The commanding officer shall take all steps for issuance of the discharge certificate to the petitioner and have it communicated in terms of Rule 12 as per Rule 12 of the Army. So the petition accordingly stand disposed in terms of the work. The entire exercise be carried out within a period of 90 days from the date of receipt of a certified copy of this order. Rule 12. Section 23.
Obliged. Still, my unfilled my lord. On the ground, my lord, kindly see case 49. Case 49 is the
49 is the
medical unfit due to corporis post inflammatory hyperpigmentation plus maybe. Now they have filed an affidavit, my lord, saying that, my lord, the finding was given on the basis of, my lord, medical opinion given by Silchar Medical College, dermatologist of Silchar Medical College. That, my lord, opinion, my lord, not annexed in the that is, my lord, required, my lord. As per my station, and I have also
show it.
Lordship, my senior is on lady. Matter may come up next. Any date.
Who is your senior?
SS Royal Lordship.
You filed an affidavit, you need to show the medical certificate. Mr. HR Ahmed, the police for the petition. It is so and so, it is on behalf of Mr. SS Royal CDC. So Mr. Ahmed submits that although an affidavit is filed justifying the section of the writ petitioner grounds. Certificate on the basis of which the candidature of the writ petition is to be rejected, namely by dermatologist in the Silchar Medical Hospital. It's not supposed to be Government CGC will produce the relevant medical records in original and place it before the court. Next date fixed. This again on.
Wait. Sir, thank you, Lordship. There is an interim in our favor, Your Lordship. Petitioner has been declared to be unfit by the review medical examination board, which has been put to challenge. They have filed an affidavit basically saying that once the review medical board has decided there is no scope for further review of the same.
Yes.
Lordship, affidavit is also filed. Lordship, matter may be come up for admission.
It is for admission hearing. What else is it for?
Then any other date, Lordship. Senior is in late.
Don't keep on mentioning all matters like that. Why are you mentioning all the matters? Senior on legs is not a ground for adjournment.
We'll pass over for the time being, Lordship.
Yes. We'll follow up again. Scroll him.
Obliged.
Sometime we given to file a reply. We have received the affidavit of respondent number 3 and 4. Sometime we be given to file a reply. We have received the affidavit of the respondent.
Counsel for the petitioner prays for and is granted this time. File the affidavit. Affidavit in opposition. And respond number
3 and 4.
3 and 4. Please take in after 3 minutes.
Obliged, Lordship.
Every. Petitioner was office peon of Ansari Content Borkota Bodali method. He was under suspension method. Suspended on 27/12/2005 and retired on 28/2015. But to till date method is retirement benefit and under other consequences. But I will interested for the all functions.
Under which department?
Here,
You are serving a where?
Bodali.
Bozali where?
As a peon in the office of the office of the Borpeta Jilia Porishod. Submission letter is an extract letter 3 page 14 and 15.
Respondent number which respondent? Video.
Mine.
Are you sure? Have you been in touch with the petitioner?
And
Are you sure his grievances have not been redressed? He's still not received.
Enter submission of pension proposal in respect of government petitioner matter that was submitted on 14/10/2022. But to treat that matter, that is
Submitted where?
that the official commissioner and PNRD Assam Pandava.
Who's for PNRD? PNRD? Hold for PNRD. Wait for some time. PNRD. Please you counterpart.
Thank you, Sir Lordship. Lordship, Mr. Kesri will appear on the for his speak. Lordship.
Ask him to connect.
Lordship.
What is the status before the NCLT?
Yes, it's the ownership matter. Presently, but Lordship is the first order, my lord.
First order.
Yes. Para 2, my lord. The complete set of orders, my lord. Para 2. Heard both sides, learned counsel for the petitioner pays for grant of status quo in regard to shareholding, fixed assets, directorship, etc. However, no case for grant of same is made out today. So, Honorable Court has refused to grant the status quo order, my lord. Then matter went on. They have taken time or due to possibility of time, the matter could not reach. So there are various orders, my lord.
I mean, those all the orders, my lord.
So after 23, what is the status? Is
Last
order-
order, my lord, your lordship may see, the matter has come, that is last order, my lord.
2nd April.
Yes, yes. Regular bench is not available today, therefore list this matter. Matter, I already demonstrated, my lord, that we have made out a case of matter referring to the arbitration, my lord. And one judgment, my lord, I want to place it. The tribunal and the high court, my lord, the jurisdiction, my lord, which is at page 67, my lord.
Oh,
67 of the compilation I have given, my lord. All the judgments.
67.
67. The body of the judgment, my lord, Article 226 and 27 law declared by High Court binding effect of primacy of orders of the High Court over those of statutory tribunal in case of conflicting orders. Now, lordship may come to page 70, my lord. Para 8. Dr. Abhishek Manu Singh, learned senior counsel appearing on behalf of the appellant, submitted that when the High Court of competent jurisdiction was already in season with the matter, the learned entity could not have entertained a list with regard to the same cause of action. Submitted that though this fact was brought to the notice of the learned entity refused to vacate the interim order dated so and so, which was in conflict with the order of the High Court so and so. The para 9, madam. Dr. Singh submitted that NCT is a tribunal which is subordinate to the High Court insofar as territorial jurisdiction of the High Court is concerned. It therefore submitted that the very continuation of the proceedings before the learned entity is not sustainable in law. Then para 11. This court in Priya Gupta versus Ministry of Health and Family Welfare has observed thus. The government departments are no exception to the consequence of willful disobedience of orders of the court, violation of the orders of the court would be its disobedience and would invite action in accordance with law. The order passed by the courts are the law of the land in terms of Article 141 of the Constitution of India. No court or tribunal, and fact that matter any other authority can ignore the law stated by this court. Such obedience would also conducive to their smooth working. Otherwise, there would be confusion in the administration of law, and the respect of law would inevitably suffer. There can be no hesitation in holding that the law declared by the higher court in the state is binding on authorities and tribunals under its superintendence, and they cannot ignore it. The court also expressed the view that it had found necessary to reiterate that disrespect to the Constitution ethos and breach of discipline have a grave impact on the credibility of the judicial institution and encourages chance of litigation. It must be remembered that predictability and certainty are important hallmarks of judicial jurisprudence developed in the country, as discipline is a sine qua non for effective functioning of the judicial system. If the courts command others to act in accordance with the provisions of the Constitution and to abide by the rule of law, it is not possible to countenance violation of constitutional principles by those who are required to lay down the law. Now, para 12.
in case no law necessary to state that so far terminals are concerned.
There is a case where I think similar issues were pending.
But here is also, my lord, practically we say that, my lord, that this is a money dispute. I will already shown it, my lord, before the various documents that
Where were we last on the last date?
last, my lord, I was reading the prayer of the from the petition, my lord, the
So-
company law petition.
So there is an agreement
Yeah.
of share holding executed.
No, shareholding, there is no dispute, my lord. We are the bona fide shareholders of the company, my lord, because we have purchased the shares.
The arbitration clause is available where?
Yes. Share purchase agreement page, my
Share
lord,
purchase.
page 67, my lord.
$67.
Yes. The petition, my lord. I am reading it, my lord, 11.10. In the event of any dispute arising
No,
under this
wait.
agreement.
This is with regard to dispute of share purchase.
Yes.
Dispute
to matter any dispute with regard to the agreement, man.
That's right. The agreement is pertaining to share purchase.
Yes. Share purchase plus to pay the consideration amount, because that is there.
Where is it provided here?
Yes. Lordship may come to page consideration is page 60, my lord. I'm reading it carefully, my lord. This is very important. The total valuation of the garden and factory has been arrived at rupees 13 crore 87 lakh 50,000, and the total valuation of 1 lakh 95,007 equity shares have arrived at rupees 1 crore 28 lakh 70,462 as per valuation report attached here. The value of the current assets as on takeover date, that is 30/4/2021, shall be paid by the purchaser to the sellers. The balance of the total value of the garden and factory as reduced by the value of shares. So that is rupees 12 crore 58 lakhs, that is minus the share money, shall be infused by the purchaser as unsecured loan over a period of time, as and when required to pay off the liabilities of the company as determined and informed by the sellers to the purchasers. The total amount to be infused by the purchaser includes any amount already infused by them as on the takeover day, in case if the liabilities of the company as on date of takeover is in excess of the amount of 12 crore 58 lakh so as informed by the seller, then the same shall be borne by the sellers. Now here, my lord, their liability was 12 crore something. Now, end of the day, we see that, my lord, the amount which is agreed in the balance sheet has over, that is, they did not pay their liabilities. As per the agreement, the seller is to pay the liabilities. So it has gone to 15 crore so, which I submitted a document to your lordship. In fact, in the affidavit of opposition, that is there. Lordship may come to page 270, my lord. Now, every day we find that some creditors come, there's a liability, they even didn't pay the gratuity of the employee also. Page 275.
Page number?
My lord, page number 270, my lord. At the end of the letter, my lord, lordship may see that as per MAU deal amount 13 crore 87 lakh 50, this is the amount agreed, my lord, minus the shareholder valuation, that is 1 crore 28 lakhs. Now,
which page you are reading? 270.
270, my lord. This is
which-
affidavit in opposition, my lord.
No, 270 is a email.
Email, yes. The bottom right, at the end of the
Hmm.
para. As per MAU deal amount 13 crore 87 lakh 50,000. That's a got it. If this is minus the shareholder valuation, then it will come to 12 crore something, my lord. Now they have additionally increased the liability to total amount, lordship may say 15 crore 62 lakhs.
This is by whom?
By the
Some creditor.
seller.
Respondent number 2, your lordship.
Respondent number Rishit Patel. This is pursuant to the agreement executed.
Yes. So there is apparent dispute, my lord. We have agreed to pay the value which has been projected in the balance sheet, and rest it was the seller's liability to pay. And there are so many documents.
What is the meaning of the last line in para 4.1?
Para 4.1, which
Page number 60.
60. 4.1, last line. The seller shall provide their respective invoices and money receipt relating to the sale of their shares in favor of concerned purchase. That has been done, my lord. I've shown that on the last occasion, my lord.
The 4.1 paragraph, last sentence,
Yes.
in case.
So, in case, if the liabilities of the company as on date of takeover is in excess of the, so that means if it is excess of 12 or something, my lord, then as informed by the sellers, then the same shall be borne by the sellers.
What is the meaning of that?
That means, my lord, if the liability comes to, because we have executed the share purchase agreement and admitted liability has been there. Now, if it is more than 12 crores, any liability comes, then it will be borne by the seller. Now, like they have done to 15 crores something.
Who is the seller?
Seller is the tea company, Belsoy Tea Estate. Earlier, they sold the garden to us.
So at the time of the MOU, it was sold to be 12 crores or
yes.
Subsequently, it has grown beyond.
Yes, my lord. Because they cannot impose other liabilities to us, my lord.
According to you, since there is a dispute, matter needs to be referred to arbitration.
Yes. And we last time is a very sarcastic statement that they made that they are the shareholders. But we have purchased the shares, we have remitted 1 crore 28 lakhs, and the share certificate the person has individually signed it, my lord. He cannot be a shareholder now.
Where is your statement that there is a change in the share certificate? Share certificate.
We have the share certificate, my lord.
So in your pleadings, there?
Pleadings. Para 3, man. A6. and para 5, my lord.
Statement here. Here,
My lord.
in the pleading somewhere.
Yeah, para 3 and 5.
So there you have mentioned about
Lordship may say para 5 that the
Para 5.
petitioner, page 9, my lord, and respondents enter into another agreement 30 for change of management and transfer of entire shareholding in the petition one company and all interest thereon to petitioner 2 and 5. And we have this share certificate, my lord, and
why are you giving us papers which are not a part of the pleading?
But I'm just
We are only asking you.
I just want to show it, my lord, that we original I'm having it, my lord, that they are the shareholder, my lord. When she herself signed it, that is Gita Patel. Herself signed the share certificate, transferring the shares to us.
Part of the
But the fact remains, my lord, we are the shareholders right now, my lord. My lord, I have also shown the trademark. What happened, my lord?
just 1 minute. Yes.
In the petition, my lord, and the affidavit in opposition, rather, my lord, they made interim prayer at page 220, my lord. That was not allowed by the court, my lord. Then they have made other prayer also, my lord, which is at page 258. Page 250, lordship may see last location, lordship, I shown it in my lord. At page 259, lordship will see that all agreements entered into by the respondents and or is their agents nominees on or after 34/2021 be declared as null and void. So they are disputing the entire purchase of the garden bed. Interestingly, my lord, the trademark, they have sold the garden to us, man. Now, trademark lordship may see it's same page 270. Point number 8. Handing over trademark. These documents have regularly been given to you, but once again, we are making a courier to the following documents. The docket number is so and so. This is of 10th March 2022 in respect. Now, what they have done, my lord, your lordship may take our additional affidavit. Now, very interesting, my lord, how they can abuse the process, my lord. Lordship may come to page 664. First, Lordship may come to
664.
page 561, my lord.
Huh?
664 also, my lord. That is agreement dated 11/1/2022. This is an agreement, an authorized agreement, my lord. There,
We are unable to find out page 664.
664, my
What
lord.
is 664?
This was
I also don't have your lordship.
additional affidavit, my lord.
The additional affidavit.
One additional affidavit, as per my knowledge, they have filed, your lordship, without the leave of the court, that we have not counted. I don't know second affidavit they have filed, because first affidavit, it's second affidavit, I don't have the copy. First affidavit, last pages of 554 is the last page, your lordship. First affidavit, last page is 554. That is what I am having, which was filed without the liberty, and I have not counted the same.
Last page in this brief is 554.
Last time.
Yes, your lordship. That is what I am also having.
It's a big volume. Last time also we have pointed out. 11 September 2005.
Your lordship, in meantime, if I may, I allow to just clarify 2 or 3 issues which was pointed out by my senior.
Official record 6625.
Your lordship, with reference to the share certificate, we have already filed a perjury proceeding.
We have filed many cases, but the question is whether all these cases will restrain the court from exercising jurisdiction under 11.6. That's the moot question.
Yes.
You have
Your
not been
lordship,
able to satisfy the court that there's any order or any contra order passed by the NCLT Kolkata
your
as on
lordship,
date.
they don't
And in
have
any
the
case,
authority.
your application is with regard to operation and mismanagement.
Yes, your lordship.
That the court will see on its own.
Your,
How
yes,
does it
your
come
lordship.
in the way of arbitration referred to in an agreement?
Kindly allow me 2-3 minutes, your lordship. Kindly allow me 2-3 minutes to apprise your lordship.
Yes.
2-3 minutes. I just want to refer, first of all, page 171 of my reply.
So first, let us find out that affidavit where it is got.
Because it is
One
there.
extra copy, Mr. Roy. Give us an extra copy.
I don't have the copy. I have not been served, your lordship. I have served that 554 copy.
Have
The
you not
last
served
page.
with the others?
Yes,
With the
No, your lordship.
respondents?
I have received one additional affidavit. That is the last page is 554.
When was it filed? Not served,
Madam,
not served.
it's served, madam, but was
They're saying that they have not been served.
I have received one additional affidavit, Your Lordship. Last page is 554.
This affidavit was filed on which date?
6/6/25.
No, there is 11.
11 September.
It was sworn on 11 September. So it couldn't have been filed on 6.
Sorry, sir,
6/6.
11, sorry.
This copy has not been served.
No, Your Lordship, I have not received.
Yeah.
Second of June 2025, I have the copy, Your Lordship. 2nd of June 2025. Your Lordship, one interesting provision is there in 242, Your Lordship. The prayer I may made, Your Lordship, for termination of any agreement that is it was apprised by my learned senior friend. I'll just take leave to read the provision of 242.
Let us first complete on this aspect of affidavits.
Yes, Your
Of the
Lordship.
missing affidavit.
Yes, Your Lordship.
Let us find that, madam.
Huh?
We'll find it out.
You find it out. We'll come back again.
Yes.
And please find out whether you have served copies to
Yes.
respondents or not.
I have not received, Your Lordship.
We'll take it up in the second half, Mr.
Madam.
Kesari,
But only I'll be
at
ready.
2 p.m.
I got one fix at 2 p.m. madam. So 3, madam.
We don't know. We'll call up because see, we need to close this matter. It's
Yes,
been
yes.
heard for a long time.
Yes.
I'll be needing
Exceptionally
15
long
minutes, Your Lordship,
time.
not more than that. I'll be needing only 15 minutes.
And we have placed one more judgment, lordship, anyway.
You find out and tell us if the
Yes,
copy is
I'll
available
apprise
or not.
regarding
Otherwise we can't proceed with the hearing.
Yes.
Yes.
I'll apprise
Please
to
inform-
judgment, Your
please
Lordship.
inform the court. If you can do it now, we'll take it up before second.
I can wait, Your Lordship, because second of 3:30, I'm having a fixed matter. I can wait, Your Lordship.
Yes.
I had gone to the brief, same the petitioners, or I have gone to the judgment also. The very work which was allocated to the petitioner does not have the component of any construction.
Did not.
And then that money
But
has
the
been,
judgment of the apex court is very clear on that.
yes, madam. So that money has been deposited to the labor commissioner, madam. 1%.
What is your view with regard to the judgment of the apex court?
Court is correct, madam. And we also see to that there was no construction of whatsoever manner in that very project. In fact, we have filed one. The clarification has come from the APDC. Lordship will read this in tandem with Annexure 3, page 33, the name of the work. And this instruction received from the DGM law of APDCL clearly reflects, madam, that no civil work of any nature was.
No, but then we have to understand what is the interpretation of the judgment
Madam.
of the apex court. Where is the judgment?
Right now.
Sure.
What is the citation? Mr. Goel,
My lords, my lords.
what is the citation? 2011. What is the citation?
My lords, my lords, I'm just opening the petition.
2021, my lord. 2021. 2021 6 SSC. 2021 6 SSC, page 15. I'm handing over microphone. Twenty-one 6 SCC 15. 15 minutes. Para 53 therein. Yes. Madam. You are saying this is a pure supply contract. There's no any element of any construction. So therefore he is exempted. Sir, Goswami?
Relying on the affidavit, I made my submission. So I have not been only confined with supply of materials. Also included
They-
construction.
They are the employers.
Yes, they are the employees, man. That was the submission I made before earlier. One of the, that is why petitioner was given the opportunity to submit all the documents from the examination documents.
You are representing the Labor Department.
Yes.
Labor Department.
That was the relying on the affidavit I made my submission earlier. That is, and the amount was also included in the estimated cost. That was my submission.
Estimated cost.
When the entire amount was considered by the authority for the purpose of floating the tender method, the amount was also included here. And
which amount was it?
That says part.
This
Tax
estimate was submitted by whom? By the petitioner.
No, authority has prepared the estimate.
So authority has deducted it.
Yes, deducted this.
Yeah, the APTCL has deducted it,
Yes.
isn't it?
Yes, you deducted a
But
bit.
now now on the basis of the judgment, you say it ought not to have been deducted.
Man, because that judgment came later.
It's their submission.
My lord.
This is their submission. Then
Yes, that is their submission and my submission in earlier occasion, my lord, relying on the affidavit filed by the State Assessing Authority, Labor Commission. That was my respectful submission. And now, representing the employer, says so, my lord.
Yes, Mr. Goyal.
It's a matter of fact, in fact. So I think, my lord, my submission.
Who is to refund the amount now?
So we have deposited the whole amount to the Labor Commission.
So you'll have to refund, remit it back.
Not that. But no problem because they have deducted, deposited it. So direction is that that will be done. But my submission was relying on the filed by the labor.
Filed by the
Labor Commission.
What is the
As per that, my lord, not only supply of work is also included by the construction, that part. And he was given the opportunity, annexure 1, my lord, to submit all related documents from which authority could have come, whether it's a factual matter, my lord.
the labor who responded number 2.
Yes, when I think, my lord. When
Does it take into account the judgment?
1. It's my respectful submission. It's a matter of fact, my lord. Whether supply work is there or my lord construction is there, my lord. Author petitioner by submitting.
Which particular paragraph of the affidavit you
My paragraph 10.
Paragraph 10.
And when the work was allotted, my lord, at that time the judgment so referred to now, my lord. That was not in place.
Dear Mr. Goyal, anything to submit?
My lords, precisely, my lords, my also submission is about I'm relying on the Supreme Court judgment, my lords, passed in 21. Since my lords, on the very last date, my lords, on the last occasion, lordship gave a direction like to simplify the judgment, my lords. On what grounds, basically, I'm claiming.
When was the contract executed?
My lords, it's since that invitation of tender like came in floating in 2019, my lords.
And when were the amounts deducted?
My lords,
When were the amounts?
Since I have raised number of invoices at the multiple stages, my lords, and
When was the
every
amount
invoice is
deducted?
And the judgment came in, I think, 21.
So when was the amount deducted or deposited?
So I mentioned the detail of deduction, my lords, in Action 4, my lords, page number 52. All the deduction, whatever the invoices are raised against my services, my lords, I also calculated and computed the amount of this labor cess part.
And he was in fact given an opportunity, my lord, by annexure 1 to the affidavit of operation.
These annexure 4 documents which we have enclosed only shows the amounts which were deducted, but not under what head.
So I think, my lord, my part is over.
We don't know. That's for you to submit.
Because
you'll have to refund the amount.
What is the direct?
Because again, it's a part of assessment, my lord. Since I requested, even I pleaded in my petition, my lord. Then subject.
He could have submitted all documents pursuant to the annexure 1 to active.
Which one?
Since
Annexure?
1.
The affidavit.
Affidavit labor commission.
We're direct submitting message, but it is 118. Have come like, have you submitted?
Did you respond to this communication at page 118, Mr. Goel?
my lords,
Page 118 of the affidavit in opposition. Annexure 1.
my lords.
Another reminder, Mother, 1.
My lords, my lords, it's something addressing to. Also, I just inquired from the concerned department, Malos, who actually addressing these correspondence, Malos. On the very last occasion, also, Malos, this query raised. When I confirmed, Malos, I just got to know we haven't received this particular letter, Malos, from the department,
You haven't received.
Malos.
But counsel for the parties. Yes. It's a company registered on Act 1956 and it's public limited. Manufacture, distribution of electronic energy meters, power distribution management projects, hybrid microcircuits, and they undertake works contract pertaining to electrical goods and transmission lines, and such works are regularly undertaken by government entities. So, response to NIT dated 201 issued by the APTCL, supply and installation of services. Petitioner applied for safe order. As after completion of the work and submission of the bills, an amount of rupees 1,87,4933 is deducted as labor component. By the labor department, the bills which were raised and amounts released thereon by the APTC. Deduction, the labor component that is seen in the so then the council for the petition submits that this deduction of the amount is carried out under the purportedly under the provisions of see the impact. There was no construction work undertaken by the petitioner in pursuance to the NIT dated so and so, issued by the APDC. So, contract for supply of goods. Is it supply or supply and erection?
My lord, it's supply and though the word construction is used, it's installation. Supply and
Supply and
Supply and
installation.
erection, my lords.
erection and installation. What?
Erection and
Both are same, my
installation
lords.
of the electrical meters. Then it comes into Power Transmission Corporation Limited. This is CG Power and Industrial Solutions. Referring to the same judgment, the Learned Counsel for the Commission submits that the apex court in the same judgment is held that unless there are construction works involved, no labor component can be deducted. CW Act. Stop there. So, supply, installation without any construction work, then such supplies are excluded from the purview of the contrary to the CW Act, therefore, nothing back. Mr. State submits that legal component was deducted by the APDCL authorities were required to open the tender. The amount further submits that kind of communication to 5525, calling upon the petitioner to submit all relevant documents. Same issue. So, submits that petitioner be directed thereupon that deduction was made.
10 or 4. 10 4. First one is 10 4.
2 letters by the Labor Commission.
Yes, letters 10/4/25.
Yes, yes.
10/4/25 and subsequently
Find out
again
the
on 5/5/25. However, petitioner spoke safely. Excluded under the purview act, then the necessary follow-up action. Mr. Goy, Learned Counsel agreement for
APDC.
instruction submits that as per the contract work, no construction work is undertaken. The case of supply and installation or erection of the fitting. Therefore, daily submits that so we get export. In terms of the in terms of the judgment rendered by the apex court, amount ought not to have been deducted. However, the same amount has been deducted and deposited with the labor department, and it is the labor department now where to take a call. Return the amount subject to such order and password. Counsel for the parties have been heard. Available on the court. NIT. The NIT issue was included. Is stated 13 February 2019. And scope of work is defined under clause 3.1 of the NIT. Expected is extracted as under case number 30. Or 24/10/2019. So defines the scope of work under clause 2.0. 2.1.2, which reads as under 2.1.1 and 2.1.2. Reads as under. Apex Court in UP Power Transmission Corporation. So dealt with issue. Action of take a proposal UCW Act. Relevant paragraphs Act from the judgment are extracted below para 50. 54. After considering several judgments of the apex court and the proceedings, the apex court held that sets under the UCW Act leviable in respect of building and other construction works. The condition precedent for imposition of cess is construction or repair or demolition or maintenance of and or in relation to building or any other work of construction, transmission towers in relation to the relay, generation, transmission and distribution of power, electric lines, pipelines. So, apex court held that mere installation or erection of pipelines and equipments for generation or transmission or distribution of power, electric wires which do not involve construction works are not amenable to cess under the PROCEEDINGS Act. It's held that new supply contracts are statutorily exempted the levy under the PROCEEDINGS. There is the judgment of the apex court. that the limit of legal scope that the applicability of CWI says that such contracts which contains components of construction, erection, etc. Supply of contracts, supply of goods and installation without any involvement of construction or erection. Sorry, construction, repair, demolition, or maintenance. Not like the DF says under the PCWI. The learned counsel appearing for the APDCA instructions are fairly submitted that it was a case for supply of contract, supply of goods, and also installation, but without involvement of construction, repair, maintenance, demolition, etc. That under such circumstances, provisions as also the judgment and order passed in by the Apex Court. It's clear that the reduction of cess by the APDCA from the final rules of the petitioner is contrary to the Act as interpreted by the Apex Court in such circumstances. So, judgment of the Apex Court interpreting terms and its applicability regarding WO deduction of labor component says same is binding score. Therefore, score is constrained to hold that the deduction of labor component amount is contrary to the power transmission corporation super. So, the department examine the matter to be furnished by the petitioner. Construction, demolition, repair, or maintenance work is found to be involved. The contract work which is undertaken by the says deducted shall be refunded for petitioner will hear before which labor authority? Labor commissioner.
It is additional.
So who issued the letter?
Additional labor commissioner, state cess assessing officer, my little find an annexure.
Additional labor commissioner
Additional labor commissioner.
will examine the entire matter.
Additional labor commissioner comes
State
Cess.
additional labor commissioner come state assessing authority officer and upon verification of the particulars in respect of the amounts deducted, if it is found that the amounts have been deducted in respect of labor component without there being any involvement of construction, repair, demolition, in respect of the works undertaken by the exercise will be completed 60 days from the date of receipt of the certified copy of this order. Needless to say, petitioner will appear before the concerned authority and furnish all necessary documents, pursuant to which the authorities will carry out the directions as contained in this order. Dispose.
Whereas that instruction may be made a part of record. Instructions
The
stated.
instructions furnished by the
With the that control without because watching alia hard. Now I'm feeling discomfort. Pain in it. So I need to check up.
discomfort not from the court.
No, from my body.
Oh, okay.
Therefore, what will accommodate be next week?
No, no, 24 to next
Friday.
week.
Thursday ki baar,
30.
38. Yes.
24 to 28.
24.
Sorry, your matter.
What was this?
Rejection review medical report.
That report has to be placed. What is it?
Case is rejected by the review medical.
What is your stand in the affidavit?
Our stand is it was taken up by the Secure Medical Board on the basis of that report.
So where is that report? That's
That-
what we. That you have to bring. We want to see that report.
Lodge.
Bring it. Bring that report in original and show it to.
Lodge.
When can you do that?
2 weeks or other 14. Other matter lodging is 6 or 14. 14th.
14th of May.
14th of
Let this matter also be listed on 14th of May. By which date done at CGC, Mr. SSY. Will place before the court the medical reports of the petitioner issued by the Signature Medical College Hospital, on the basis of which the petitioner's case was rejected by the review medical. Interim order passed away. Under the next listing. Yes, PNRD, what has happened to this? See this communication. You have another copy? No. Papers have been sent, but there is no response.
Lordship, as per my instructions, the proceedings are still pending. I mean, on last 29/7/25, a hearing was conducted wherein the petitioner attended. Although the decision is yet pending.
When was the proceeding initiated?
Shit, the exact date. The show cause was on 2006.
Then?
The petitioner didn't reply, nor did he
When was the last date?
last date of lordship.
You said the last date he appeared.
Yes, it was on. A notice for hearing to the petitioner was sent on 21/7/2025. I'm awaiting the updated instructions to what is the outcome of the proceedings.
2006 matter will continue for 20 years.
No, Lordship, the thing is that while initially he has been absent, unauthorized absent, some notices were sent to appear, join his office. He didn't reply to those notices. He was suspended on 2005.
See, this is matter is still at the stage of inquiry.
Your Lordship, a hearing has been conducted wherein the petitioner is attended.
Before the inquiry officer.
Lordship. Your Lordship may grant me some time to sign. Obtain the updated instruction.
We are directing closure of this matter, this, and pass appropriate orders within 4 weeks. The inquiry. When was the last date you said?
Lordship,
No, tell us the last date.
notice for hearing was sent on 21/7/2025.
21/7 must have been, should have been completed by now. Heard. In a council of the parties. Petitioner before this court, serving this view. Where were you serving?
Bajali Anchalik Panchayat.
Annexure 2 page.
The Bhojali
Anchalik.
Anchalik Panchayat office. Stop. Purported unauthorized absence, petitioner was placed under suspension and inquiry proceedings was initiated. Petitioner was placed under suspension by which order?
13.
Annexure 2 page 13.
314. Yes.
With effect from 27th of December 2025. Stop 2005. Thereafter, show cause notice was issued and in the year 2006. Is the show cause here?
Yes, Lordship. The next 16.
Issued the 19/8/2006, calling upon the petitioner to submit his reply to the charges against petitioner. So, pursuant thereto, the inquiry officer was appointed and the inquiry proceedings were initiated. So, an affidavit has been filed by the CU for better Zilla report.
As well as the director, Lordship.
Director was also filed.
Yes, Lordship. Respondent number 3. There are 2 affidavits. Respondent number 3 is affidavit.
Joint Director, PNRD, has filed an affidavit. Submit that since the petitioner was unauthorizedly absent from his duty for the last few months, did not respond to several notices, was placed under suspension. Show cause notice was issued and petitioner was served upon a notice to furnish his reply. No such reply was submitted. And thereafter, the petitioner submitted an application requesting to release the entire assignment. So, according to the petitioner, according to the counsel for the petitioner, he could not attend his duties and he was suffering from psychiatric disorder. respondent authorities directed the petitioner to appear in court, medical court, constituted to examine the petitioner. However, the same is not done by the petitioner. Other submitted an application in opinion from the OPD. To find that the petitioner is suffering from chronic ischemic stroke for a particular period. CEO Barbara Zilla has also filed an affidavit protesting the case of the petitioner. Stop. The CU supported the case projected stand reflected by the director, joint director, PNRD, and further stated in the affidavit that subsistence allowance was paid to as per the provisions of the Act. The rules, FR, fundamental rules. Stop. Petitioner filed joined the affidavit. CU reiterating this case as presented in the petition. Available before the court see that the petitioner has been placed under suspension and his financial benefits have not been released, particularly because of the fact that there is a inquiry proceedings initiated against the petitioner in pursuance to the show cause notice issued dated so and so. So, from the evidence, it is clear that the petitioner did not participate, did not file his response. Stop. The status of the inquiry report is not reflected in the writ petition. However, on oral instructions, the standing counsel for the PNRD department is submitted before the court that the last date of the hearing, the inquiry officer was on
21/7/2025.
21/7/2025. Stop. Subsequent status of the inquiry report. Status of the inquiry report is on date is not to the respondents to the standing counsel. Stop. He submits that he would like to obtain the instructions if such instructions. Prayer before this court in the writ petition is for direction to the respondents to grant the GPF pension, arrear, outstanding salary, and other allowances. So, while specific challenge to the inquiry proceedings initiated, the fact remains that the respondents have initiated an inquiry, and on the basis of the said inquiry, and as the said inquiry is stated to be still pending, the prayers made by the petitioner has not been redressed by the department. Stop. What is distressing to notice is that the inquiry proceeding was initiated by way of issuance of the show cause the year 2006, is it? Page number
13.
2006. 1908-2006. So, from the evidence made in the affidavit, you can see that the proceedings that the notices issued to the writ petitioner have not been responded by the writ petitioner. And as a consequence thereof, the inquiry proceedings lingered on. So what is not explained by the department in their affidavit is why the inquiry had to continue from 2006 onwards for 10 years till when the writ petition was filed in 2016. So even as on date, there is no official explanation furnished by the department, either by way of their affidavits as filed or by instructions to the standing counsel as to why the inquiry proceedings have not been concluded for 20 years. So such inaction by the department leading to delay in the conclusion of the proceedings strongly deprecated. So whether the petitioner would be entitled to this claim for release of financial benefits, other area, other claims for the real salary is one aspect of the matter. But the fact that these claims have not been entertained solely on the ground that the proceeding initiated against the petitioner has kept pending, has not been concluded, it's trouble both sides of the court. So, time and again, this court, as also the apex court, has laid down several judgments directing respondents to expeditiously conclude the departmental proceedings. And pass appropriate orders by the disciplinary authority where required. So, reference in this case will be made to judgment of the apex court in Rednath Balli, reported in so and so. This judgment of the apex court has laid down clear parameters for conclusion, expeditious conclusion of departmental proceedings against the government servants. So, some services discipline and appeal rules, 1964, read with the manual of departmental proceedings appended also emphasizes on early disposal of departmental proceedings. So, such circumstances, it is necessary to direct the officers, the respondents, more particularly Director of Panchayat and Rural Development, namely respondent number 3, take all steps necessary as per the provision of law to conclude the inquiry proceedings initiated. Is the inquiry officer
So that is not in the.
to issue instructions to the inquiry officer appointed to conclude the inquiry proceedings as expeditiously as possible. So, if the inquiry officer upon conclusion of such inquiry proceeding, the director, being the appointing authority, will take all necessary steps as prescribed under the Assam Discipline and Appeal Rules 1964, pass specific orders thereon in terms of the inquiry report that may be submitted by the inquiry officer. So, needless to say, copy of the inquiry report must be served on the writ petition before the appointing authority proceeds to pass orders against the interest of the writ petition. So, depending on the outcome of such inquiry report and the consequential orders passed by the appointing authority, further claims of the writ petition will require examination at the hands of the respondent. Stop. However, the pendency of the inquiry proceedings and of the court, any such orders required to be passed by the appointing authority post the conclusion of the inquiry shall not be a bar for release of the outstanding area salary payable found to be payable to the petitioner for services rendered. Shall be released without further delay. So, the inquiry be completed within a period of 30 days, 45 days from the date of receipt of the certified copy of this order. Thereupon, procedure prescribed under 9 capital A of the Assam Discipline and Appeal Rules 1964 be proceeded with by the appointing authority if found necessary within a further period of 30 days. The petition accordingly stands disposed. Mr. S.K. Medifor is responding to Accountant General M.S.B. Bora for 7 and 8. Disposed. Mr. Ghosh for PNRB.
Item 23.
Yeah.
Lordship, I am appearing on behalf of Mr. Esna. Lordship, he was supposed to come, but he is feeling not well. Kindly consider matter possible for today. Lordship, it's a matter of a family pension. Can it be fixed on next week?
You do it. He's not here, you are there, you read the file.
Lordship, I am not there.
You're not there, we're
I am
appointing you.
proxy
Do it at 2 p.m. We are giving you some time, 1 hour to go through the file and appear before the court. Do it. PM. Family pension matter.
Lordship,
You are the first wife or second wife or third wife? First wife. So you know something about the matter.
And Lordship, next week.
All right, and the request made by the counsel for petitioner, matter stands referred to the next week. So then it comes for hearing, let it be in the part 2 hearing list of June.
Yes.
Be listed on the part 2 hearing list of, be prepared by the registry. You make a mention, upgrade it from the part 2 list, we'll take it up.
Okay.
Mr. S.K. Medi for responding 3.
Obliged, Lordship.
Mr. Roy, your affidavit is not here.
It's like some defect, my lord.
All right.
So,
Then it has to go post lunch.
only thing, my lord, one request, was 2 o'clock, my lord,
Let us see. Let the affidavit, if you filed an affidavit, it should come on
Yes,
record,
yes.
then copies will have to be served.
I had it three document page I have to show.
All right, all right.
I don't have
And
the
copy.
copy. I have not received that copy as well, Your Lordship.
This is the proof of serving of copy to them.
You show it to the council.
Yes, Your Lordship.
local
Can I have
council
it
who's
recorded?
appealing.
My submission as well that I have not received, Your Lordship.
No, but somebody has received it.
The local council.
Upon instruction from my AOR, Your Lordship. I'm making this submission upon instruction from my AOR. He's there physically.
All
Your
right,
Lordship.
we'll hear on that at 2 p.m. At 2. Mr. Roy at 2. At 2 p.m. You have some matter at 2. All right.
Fixed matter.
Then
Only thing some accommodation 230 or
Your
we'll
lordship,
see if there are matters available. We'll see. Otherwise, we can have it on Thursday, day after.
Thursday I will be out of station, my lord. Maybe on 28th, then or 27th, my lord.
We can't keep on
Or
reading.
tomorrow, my lord.
Why you trouble the court
My lord,
to
tomorrow
read the file? Tomorrow is a miscellaneous day. We don't know whether we'll be able to have time.
we'll take a chance, my lord.
Let us reassemble at 2 p.m. and see. You ensure your affidavit is on record first. Because if there's an objection raised that they have not been served with a copy.
No, there's a the copy is there.
It's not one.
But whose signature is this?
We'll
This
examine.
doesn't mind.
We'll examine it at
Signature
2
is
p.m. 2 p.m. Yes, Mr. Sharma, yes.
My lord, in this case, I have in compliance with the last order, the 21/2026, I have submitted my written argument, my lord, by this honorable court for the convenience of this honorable court, because my lord, this is the third litigation arising out of the third WPC case in paragraph A2 from page number 2, my lord. The present repetition is the third round of litigation arising out of
What is your prayer here? What is your prayer?
my prayer, my lord, actually, in the first WPC case that has been disposed of after hearing both the parties on 12/6/2017. My prayer is for relieving arrear salary and pensionary benefits, and arrear salary with effect from initially 1/1/2006 to 1st February 2008, again from March 2008 till my date of retirement, 2017. And that arrear salary had not yet been paid from March 2008 till 2017, my lord. That has been withheld by them. They had taken given the allegation that due to my unauthorized absence for a very limited period, or for only 1 year, I had taken leave on medical ground due to I have lost the vision of my right eye.
Tell us what was the direction in the earlier writ proceedings? What direction was issued?
Yes, ma'am.
Page number?
Page number 90 to 95.
90?
90.
90.
90 to 95. Relevant portion by paragraph 7. Paragraph 94, my lord. Page number 94, paragraph 7, my lord. I have considered the submissions advanced by the guarded counsel for the parties. I have also perused the materials available on record. Granting the prayer of the writ petitioner in the given circumstance would amount to allowing the writ petition without there being any confusion in the departmental proceedings initiated by the department, as may be noticed herein above. The various documents referred to by the writ petitioner and the documents relied upon by the respondents would require meticulous examination, which in my considered opinion can only be exercised in a proper departmental inquiry. In that view of the matter, instead of dwelling upon the various documents presented before this court, the writ petition is disposed of with the following direction. There are 4 points. Number 1, the respondent department will proceed with the inquiry proceedings from the stage of the so-called notice that is 14/8/2009 issued to the writ petitioner, and the writ petitioner shall submit his reply to the same phrase in terms of the notice within 10 days. And the petitioner shall also be permitted to examine and inspect all documents proposed to be relied upon in the inquiry proceeding. Number 1. Number 2, my lord, the petitioner shall join his post immediately, and the respondent's authorities shall examine the admitted dues pending against his salary. He shall be entitled to his salary otherwise from the date of his joining his post. Considering the fact that the petitioner is due to superannuate in the month of December 2017, the departmental authorities shall conduct the inquiry proceedings as expeditiously as possible and within the outer limit of 3 months. Number 4, my lord, the inquiry proceedings shall commence immediately from the date of receipt of a certified copy of this order,
It is also hereby provided that the petitioner will be allowed to put his signature in attendance register and he in turn shall give co-person in the inquiry proceeding.
Then what happens?
Now, my lord, after passing this judgment, they did not furnish the documents as annexed with the so-called notice. So-called notice, my lord, annex are 24. Lord, say kindly turn to page number 185, page 189, page 185, my lord. The so-called notice.
My lord, after that, he files a contempt case. Lordship will file my lord. Annexure 2, my lord, page 96. A contempt case has been filed alleging that we had not followed the court's orders. Then what happens, my lord? We conduct, my lord, I'll say, my lord. My lord, no, I'm just keeping it in a nutshell, my lord. Then he files a contempt case that we have violated court's order. Then, my lords, every proceeding comes down, and then, my lords, the court then he is found entitled to a certain amount of money. My lord, the page lordship will find at page 97.
My lord, this is the hearing that
Everything was same.
My respectful submission, I may be allowed to submit.
No, minus what he
My submission.
The petitioner is opening the earlier the issues which have been decided earlier. My lord, it was that inquiry report was never challenged.
Conclusion in the contempt case.
Contempt case, it was closed, my lord, because everything was found. My lord will find at page 97.
96, 99.
97 from the bottom, my lords. That entitlement, areas entitlement he was given, my lords. It was evaluated, he was paid, my lord.
What is writ petition 744?
744 is a petition filed, my lord, subsequently to death, where he had added some dead persons as a party, and so that was withdrawn by him.
Is there any order of 744?
My lord, this is the WPC 744. Inadvertently, the typing mistake. It is actually the second WPC case.
744 is a page 112, my lords.
774, my lord. It is annexer 5, my lord. I had SLD expert inquiry in the second WPC case. After during the pendency of the contempt case, my lord, I have SLD expert inquiry and to release all the area salaries. But that case has been withdrawn, my lord, because against second cause of action error, we give permission of this honorable. Because I was going to file an amended petition, honorable would have given suggestion to file a fresh WPC case, and hence, my lord, this is the third litigation. Assailing the expert inquiry report as well as the two letters by which they are going to fix by
now pursuant to the directions of the first writ petition.
Yes, my lord.
The inquiry was completed.
Expert inquiry report without any prior notice. After about 1 year, they have done.
They have done. They have served you a copy.
Answer 3, my lord.
And is there any order passed by the appointing authority? Disciplinary authority.
Disciplinary authority. One superintendent engineer was appointed without giving any intimation to the.
Not inquiry officer. After the inquiry report, what happened?
After the inquiry report, my lord, they had, as per the judgment, they should be released by admitted dues, but initially only a nominal amount of 78,000 had been released. That is not as per not ROP rules. But ultimately, to get relief from the contempt proceeding, they had issued sanction an amount of 7,29,000. NSR 40.
No, what was the conclusion of the inquiry report?
Conclusion of the inquiry report, my lord, expert inquiry report. But behind my back, I have submitted my reply, my lord, that has got no legal validity in India I law because it is a clear violation of Assam Service Rules of 1964.
All right. Fine, nine. Any part 2 matters? Yes.
Item number
16?
6.
166. From 101 to 120, any matters, your file is not available. You may renew your prayer on Thursday, subject to availability. 160 is included in the party list. 145 Thursday. Yes, Mr. Dor.
I was here.
All right, we'll take it up on Thursday.